Hello friends, I welcome you all at Swayam platform. I Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University, welcome you all. We are discussing a course Hindu Personal Law including marriage and succession. Friends, today we will discuss about the general idea related with divorce, and particularly we also start discussion on the fault theory of divorce, and we will deal a topic adultery under this head. Friends, but before starting the today's lecture, I want to conclude what we discussed in the last class. In the last class we discussed about the voidable marriage. Friends, voidable marriage provided under section 12 of the Hindu Marriage Act, where a person may declare the marriage null and void on the ground which is mentioned under section 12 of Hindu Marriage Act. Friends, we discussed the idea of force and fraud. We also discussed that pre-act pregnancy, and we discussed the consent if not obtained properly. These are the ground of the voidable marriage. Friends, voidable marriage means so long as it is not declared void by the court, then it considered a valid marriage. Friends, in the last class we also discussed about the difference between voidable and void marriage. In this context we understand that voidable marriage void ab initio, but voidable marriage from the date of judicial declaration. The grounds of void marriage mentioned in section 11, which is the section 5 subclass 1, subclass 4 and 5, monogamy, private degree relationship and sapinda relationship. But the grounds of voidable marriage are different, which is mentioned in section 12 of Hindu Marriage Act. Friends, the remedy of the void marriage is only available in a case of where the marriage is solemnized after this act. But the remedy of voidable marriage is retrospective and prospective. Therefore, the remedy available whether marriage solemnized before the act or after the act. Friends, after the concluding the last lecture, now I want to focus on the today's topic, and the topic particularly is ground of divorce, general introduction, fault theory and adultery. We will discuss this topic in today's lecture. Friends, before starting I want to highlight you the learning objectives of the today's lecture. The learning objectives includes history of divorce under the Hindu law, different theories related to divorce, divorce under Hindu Marriage Act 1955, fault theory and its meaning, and we also discuss the adultery as a ground of divorce. So these are the objectives where we understand the history of divorce in India, also the present provisions related with the divorce in India, and we will focus on the adultery especially, and we also understand the different theory which is related to the marriage and divorce, which help us to develop the concept related with divorce, as well as it is useful for the proper interpretation of the provision. Friends, now I want to focus on the history of the divorce under Hindu law. Friends, we have a two set of normative conclusion. Friends, the one scholars concluded that there is a no divorce provision in the Shastric Hindu law. Friends, why they concluded in such a way? Because they concluded that divorce was unknown in Shastric Hindu law because marriage was regarded as an indissoluble union of husband and wife. Once you married, continue your married life, and therefore there is no chance of dissolution of marriage available in the Shastric Hindu law. The Manu declared that a wife cannot be released from her husband either by sale or by abandonment. Friends, the Shastric Hindu law does not recognize any concept of divorce under the ancient Hindu law. But this idea is not a conclusive, friends. Friends, the rule was that the wedlock was unbreakable and the marital bond exists even after the death of the party to the marriage. Friends, divorce was recognized as a matter of exception in certain tribes. Friends, to live together was considered the highest dharma of the husband and wife, and the duty of the wife continues even after the death of the husband. She can never have a second husband. So, this is a Shastric position of marriage and divorce in India. In one hand, scholars concluded that marriage cannot be dissolved because we think that marriage should be continued. But friends, this approach is a general approach. This laid down the general rules. These rules also have an exception which is recognized by Narad Smriti, by Kautilya and many scholars, friends. So therefore, no one can conclude that in India there was no provision of the divorce. Friends, women are allowed for the leaving the husband in many circumstances, friends. For example, I want to quote you Narad Smriti 4:1297, where Narad concluded that naste mrite pravijite klive cha patito pati panchas ताऊ तशु नारिणाम patiranyo vidhiyate. Friends, as per the Narad Smriti, when the husband is lost or dead, when he has become a religious atheist, when he is impotent, when he has been expelled from the caste, in these cases, a woman may be justified in taking another husband. These are the conditions under which second husband may be accepted by the wife, because in a case of naste mrite pravijite klive cha patito pati, she cannot enjoy the married life. Therefore, she may left the first husband and may enter to the another wedlock. This is the provision of the Narad Smriti. Friends, apart from the Narad, the Parasar Smriti also identified a situation where wife have a right to leave the marriage and adopt another husband. For example, friends, when her husband is missing or is dead or has renounced the world or is impotent or has been disregarded by sin on of any of the said 5 problems, she can remarry, friends. Friends, the idea of Kautilya is also supported about the right to life of the woman, where Kautilya concluded that marriage might be dissolved by mutual consent in a case of unapproved form of marriage. Friends, this is another view which provides lot of information that women have a right to enter into the second marriage. So now we are able to conclude that under the Shastric Hindu law we have a 2 approach, 2 set of arguments. In one set of arguments, set of scholars concluded that marriage should be continued, therefore there is no chance of divorce and deprivation. But in another hand, Narad and Parasar Smriti concluded that certain circumstances are like the frustration of marriage. In such kind of frustrating situation, wife is allowed to enter into the second marriage. And Kautilya is also dynamic by arguing that divorce by mutual consent is possible in a case of unapproved form of marriage. Friends, now I want to focus on the law of divorce under the Hindu law. Hindu Marriage Act 1955 has introduced a vital change in the Hindu law of marriage and divorce. Friends, now the law has established a clear provision for the divorce under certain circumstances. For this reason, some scholar says that Hindu marriage is no more sacrament and it has converted into a contract. Due to the introduction of the provisions related with the divorce, one set of scholars arguing that Hindu marriage cannot be considered a sacrament because parties are free to break the relationship and remarriage. Friends, so now therefore the question is whether this view is correct or not, because view is due to the divorce provision Hindu marriage is no more sacrament, but the question is whether this is correct or not. Friends, the term sacrament implies the capacity to perform yajna, and it is essential for the husband to have his wife by his side during its performance, and marriage was considered as sacred and indissoluble union. Sacrament is associated with yajna, it is duty and duty of husband, and law also imposed obligation on husband. He or she should perform each and every religious ceremonies by collectively. Friends, marriage is considered a sacrament not simply because divorce was not accepted. Therefore, the introduction of divorce does not affect the sacramental character and the nature of Hindu marriage. So, therefore, friends, we are able to conclude that Hindu marriage is still sacrament, it is not a contract. Mere introduction of divorce provisions cannot change the nature of Hindu marriage, because divorce is exception, marriage is the rule. Sacrament means they are, as per Dharma Shastra, considered eligible to perform yajna with each other. The religious rites cannot be performed by anyone independently. Therefore, we are concluding that Hindu marriage is sacrament not only and solely on the basis of the provision of divorce whether exist or not. Friends, now I want to focus on the theories related with the divorce. The number of theories related with the divorce, it includes first, indissolubility of the marriage theory, divorce at will theory, guilt or offense theory, which is now known as fault theory, frustration of marriage theory, divorce by mutual consent theory, and irritable breakdown theory. So these are the theory. By knowing this, we are able to understand the idea of marriage and idea of divorce under the Hindu law. Therefore, I want to discuss with you about the theories related with the divorce, friends. The first theory is indissolubility of the marriage theory, friends. This theory is originated by the Shastric Hindu law. According to this theory, the marriage is a lifelong, unbreakable bond between husband and wife. Parties of marriage have to live with it from beginning to end. It is the union of bone with bone, flesh with flesh. The marriage could neither be dissolved by the act of the parties nor by the death of any of them. Marriage continued beyond the death. Why, friends? Therefore, scholars concluded that Hindu marriage is undissoluble union. Friends, generally it was the law upheld by the upper class, while the tribes acknowledged divorce and followed their own customs relating thereto. Friends, Hindu Marriage Act changed the Shastric position. Now marriages are no more an unbreakable union. 13 capital B of Hindu Marriage Act brought about the revolutionary change on the point of indissolubility of the marriage. The first theory is indissolubility theory, friends. Generally, it is concluded that Hindu marriage cannot be dissolved according to Shastric Hindu law. and it is associated with the nature of Hindu marriage. But due to the insertion of the divorce provision in Hindu Marriage Act, now this theory is not as rigid as like Shastric Hindu law. The next theory of the divorce is divorce at will theory, friends. How we can explain the idea of will theory in divorce? Friends, marriage can be ended by either party at any time purely based on personal will. Purely based on personal will. The theory supports the idea that individuals have the right to dissolve a marriage at any time without the need for legal justification or mutual consent. Friends, it is recognized in the Muhammadan law and the husband has authority for such dissolution. Hindu Marriage Act gives no room for this theory, friends. So, divorce at will theory means marriage may be dissolved at your will. There is no responsibility to provide reason, justification or any kind of fault for the divorce. Your marriage may sustain on the basis of your wish, and the best example of will theory is reflected under the Muhammadan law, where husband have arbitrary power to dissolve marriage without quoting and referring any kind of reasons and justification. Friends, the next theory is guilt or offense theory, which is now known as the fault theory of divorce. Friends, if a party commits a matrimonial offense, then the aggrieved party may seek divorce from the delinquent spouse. Friends, a matrimonial offense includes adultery, cruelty, rape, sodomy, bestiality. Friends, here divorce is viewed as a punishment for the matrimonial offense committed by the spouse. The basic premise of this theory is that the party is guilty of a matrimonial offense and he intentionally did it. Friends, later the guilt theory was modified into the fault theory because of some instances like divorce on the ground of venereal disease, desertion. The party may not have acted intentionally, rather he has made a fault. So primarily the law presumes that you intentionally committing something and insulting your partner. Therefore, your partner on the basis of your fault may obtain the degree of divorce. But by the progressive interpretation by the Supreme Court and other different courts in India concluded that when we are going to discuss any kind of fault theory, we are not interested to examine and identify the intention of the parties of the marriage. We are bound to separate the intention when we are going to discuss the behavior. Behavior per se is sufficient. On that basis, we are able to derive the intention of a conductee. This is the point, friends. Friends, this theory has been accepted by Hindu Marriage Act and the theory is recognized under section 13 subclass 1, grounds available for the husband and wife both, and section 13 class 2 grounds available only to the wife, friends, especially. Friends, now divorce is seen as the consequence of matrimonial fault committed by either party. Therefore, nowadays fault theory is statutory recognized and have a value in the discussion of divorce, friends. The next theory is frustration of marriage theory, friends. Friends, this theory suggests that when the core purpose of marriage is no longer achievable, the union may justified be dissolved. The purpose of marriage is not going to fulfill. How you are continuing your marriage? This theory is known as frustration theory. If the fundamental objective of marriage are frustrated, continuing the relationship loses its meaning, friends. the marriage may be frustrated by a party to the marriage even through the other party is not guilty of any marital offense. Friends, for example, suffering from any physical and mental unsoundness of mind, there is no intention, but due to this, there is no meaning of marriage in practice, and therefore a person may dissolve the marriage. Friends, Hindu Marriage Act 1955 recognized these grounds as being good for the divorce. Friends, Hindu Marriage Act 1955, especially section 13 under bracket 1 sub capital A, provides the ground of divorce in a case of decree under the section 9 and 10, restitution under section 9 and judicial separation under section 10. And there has been no resumption of cohabitation. On that basis, party may obtain the decree of divorce. Friends, this is the frustration theory which is incorporated under the section 13 under bracket 1 capital A. Friends, now I want to focus on the irretrievable breakdown theory of marriage. Some scholars try to mix the frustration theory with irretrievable breakdown theory of marriage. But just I want to clarify with you that the Law Commission of India in its report number 71 and 217 suggested the incorporation of irrebuttable breakdown of marriage as a ground of divorce under the Hindu Marriage Act. Friends, in a case of Naveen Kohli versus Neelu Kohli, 2006 Supreme Court, the Supreme Court also recommended Union of India to amend the Hindu Marriage Act 1955 and to incorporate irretrievable breakdown of marriage as a ground of divorce. Friends, it is important to highlight that the mutual consent means both the parties must agree. If one party refuses to cooperate, this ground of divorce cannot be used. But in contrast to the mutual consent theory, the irretrievable breakdown theory is a ground that the court can independently determine that marriage is beyond repair. The court independently determines that marriage is beyond repair. The relation of husband and wife may be strained, be due to the emotional distress, sexual urge, or interdependency or social censor. Therefore, court felt that it is a problematic and therefore it should be resolved generally on the basis of irretrievable breakdown of the divorce. The court may grant a divorce decree under Article 142 of the Constitution. Friends, but people are also mixing the irretrievable breakdown theory with frustration theory of divorce. Now friends, the next theory is divorce by mutual consent. When both the spouse agree to end the marriage, the law should recognize their decision without requiring proof of fault. Friend, mutual agreement between partners is sufficient for the dissolution of marriage. Hindu Marriage Act 1955 recognized divorce by mutual consent. Friends, the provision was added by the amendment in the 1976 under section 13 capital B. Now we have provisions related with the divorce by mutual consent. So these are the theory. On that basis we are able to understand the nature of marriage as well as the scope of divorce under the Hindu law. Friends, this is the theories related with the divorce under the Hindu Marriage Act. Friends, now I want to start my discussion on divorce under the Hindu Marriage Act 1955. Friends, Hindu Marriage Act 1955 provisions are related to the divorce has been amended 3 times in the year 1964, 1979 and most recently in 2019. Friends, the provisions related with divorce is retrospective and prospective both. Friends, a petition for divorce can be filed only by the husband and wife. The third party is not permitted to initiate such a petition. Friends, a divorce is not legally recognized unless it is granted by the competent court or an appropriate authority or appropriate community on the basis of the custom. Because friends, still customary divorce is recognized under section 29 of Hindu Marriage Act. Friends, now the law is very simple and clear. Under the Hindu Marriage Act, marriage survived unless and until there is a formal declaration of divorce. Therefore, formal declaration of divorce by the competent court is mandatory. This rule is absolute, have only one exception, that is customary divorce. Friends, the provisions related with the divorce has been amended as I discussed with you, friends. Friends, I want to discuss a case, Iswar Singh versus Srimati Hukam Kaur, AIR 1965, Allahabad High Court 464. The opposite party, Srimati Hukam Kaur, filed an application under section 488 criminal PC against the applicant on the allegation that the applicant was her husband and he was neglecting her and also permitted her to marry any other person. It was complained before the magistrate, friends. The order of magistrate shows that even if the opposite parties' allegations are held to be true, it is difficult to hold that it will amount to the divorce within the meaning of section 13 of the Hindu Marriage Act, because a divorce which could result in the dissolution of solemnized marriage has to be obtained by one of two parties on presentation of a petition from a competent court, so long as such a divorce has not been obtained, the previous marriage subsists, and therefore the second marriage cannot be contracted by a Hindu so long as his spouse is living. Means, friends, so long as there is no formal declaration of dissolution of marriage, no one is free to marry. Because if anyone going to enter in second marriage without formal declaration of dissolution, they may violate section 5 subclass 1, because rule is very clear and simple, neither party has a spouse living at the time of marriage, friends. Means the conclusion of Iswar Singh case is, if the contention of the applicant may considered as true, then marriage cannot be dissolved without a competent authority, friends. Friends, in the case of Damodar versus Urmila, the Rajasthan High Court held that the panchayat of a community has no competence to grant divorce in absence of custom governing them. The panchayat and community may do, but they are totally dependent on the custom, and custom must be a valid custom, friends. Now I want to focus you the statutory provisions related with the divorce. The divorce may be categorized in two different grounds: statutory divorce and customary divorce. The provisions related with statutory divorce is given in section 13 under bracket 1 capital A, 13 capital A, 13 capital B, and customary divorce is given in section 29 of Hindu Marriage Act. Friends, statutory divorce may be categorized in three broad categories: fault theory, frustration theory of marriage, and mutual consent theory. The fault theory provided under section 13 subclass 1 and 13 subclass 2, friends. And frustration theory, which is also known as irritable breakdown of marriage theory, it is provided under section 13 under bracket 1 capital A, and mutual consent theory is provided under section 13 capital B of Hindu Marriage Act. Friends, the fault theory may further categorize into broad category: grounds available to both husband and wife, ground available exclusively to the wife only. Friends, section 13 subclass 1 includes 8 grounds, and the grounds are available to both husband and wife. It includes adultery, cruelty, desertion, conversion, unsoundness of mind, venereal disease, renounce the world, not heard for 7 years. These are the 8 grounds which comes under the category of fault theory, grounds available both husband and wife. Friends, the second set of the grounds is specially available to the wife only, which includes pre-act bigamy, husband is guilty of rape, sodomy and bestiality, non-redemption of cohabitation after the decree and order of the maintenance, and repudiation of marriage. So these are the 4 grounds especially available to the women. Friends, apart from this, friends, we are bound to think about section 14 and 15 of Hindu Marriage Act as well as section 23 of the Hindu Marriage Act. So therefore, the comprehensive provisions related with the divorce may be categorized as section 13, 13 under bracket 1 capital A, 13 capital A, 13 capital B, 14, 15, as well as section 29. These are the provisions are related with the statutory provisions and statutory protection. Friends, now I want to focus on the statutory divorce under the Hindu Marriage Act 1955. Friends, by this I will focus on the fault theory under section 13 and subclass 1. Friends, the provision is very clear and simple. Section 13 subclass 1 provides that any marriage solemnized whether before or after the commencement of this act may, on the petition presented by either the husband or the wife, be dissolved by a decree of divorce. And adultery is the first ground of the dissolution of marriage, which is given in section 13 subclass 1 friend. 13.1.1 provides that after the solemnization of marriage, had voluntarily sexual intercourse with any person other than his or her spouse. Friends, sexual relation that does not constitute matrimonial offense of adultery. It includes premarital intercourse, intercourse which is not voluntarily, suppose in a case of it happened with the force and fraud, and victim of rape. She cannot be divorced on the basis of adultery. Friends, the premarital intercourse which is not voluntarily, or rape victim cannot be divorced by using the provision of adultery. Friends, now the rule is, after the act came into the existence, no provision of second marriage and any sexual intercourse with other's wife comes under section 13.1.1. Friends, adultery is also defined under the criminal law, but the concept of criminal law and matrimonial law is different. I want to just focus on the adultery under the criminal law. Friends, section 497 IPC provided that time, not today, whosoever has sexual intercourse with a person who is or whom he knows or has reason to believe to be the wife of another man without the consent or convenience of that man, such sexual intercourse not amounting to the offense of rape is guilty of an offense of adultery. Friends, the provision of the adultery which was given in IPC now become unconstitutional due to the Joseph Sign versus Union of India, AIR 2018, Supreme Court, page number 4898. Therefore, friends, Bharatiya Nyaya Samhita 2013 2023 has not incorporated the provisions of adultery. Friends, now I want to focus on the provisions of adultery under the matrimonial law. The only test for the adultery is either party to marriage had voluntarily sexual intercourse with any other person. Earlier, before the amendment in the year 1976, the phrase used in section 13(1)(1) was person living in adultery, which means a person should continue to be in an adulterous relationship. But after the amendment, the word adultery has not been used in section 13(1)(1), but the phrase used is had voluntarily sexual intercourse with any person other than his or her spouse. This suggests that even a single act amount to adultery. Friends, now the term adultery is not mentioned in the present Law of Hindu Marriage Act, which is amended in the year 1976, friends. In prior to that, adultery terminology were there. Friends, the point is the consensual sexual intercourse between the married person and another person of the opposite sex during the substance of the marriage amount to had voluntarily sexual intercourse with any person other than his or her spouse. Section 13(1)(1) does not include attempt to commit adultery as a ground of divorce. Therefore, adultery is one thing and attempt to commit adultery is different thing. Friends, now I want to focus on the standard of proof required for proving adultery. The no requirement of direct evidence, because to get a direct evidence is an act of adultery is extremely difficult. Therefore, circumstantial evidence is accepted as a proof. Friends, no eyewitness is required, only proof is on the basis of the gravity of the offense. Under the matrimonial law, the standard of proof is not proof beyond reasonable doubt, but on the basis of propounds of the possibilities. Friends, the circumstantial evidence need not reach to certainty, but must carry to high degree of possibility. This is the requirement of standard of proof for the purpose of proving the adultery, friends. Friends, now I want to focus on the English cases on the adultery. Preston Jones versus Preston Jones. Only evidence of adultery was birth of a normal developed child within 360 days after last marital intercourse between the parties. It considered adultery, friends. Radpith versus Radpith. If the wife is raped by another man, it cannot be considered as adultery. Dennis versus Dennis. The act of sexual intercourse need not be complete. It is not necessary that such penetration should constitute a complete act of intercourse, but an attempt without penetration is insufficient. Some penetration by the man must be found to have taken place. Friends, now I want to focus on the Indian case on adultery. Gopi versus Pushpa. No complaint of adultery can be maintainable in a criminal court on the ground of the charge of adultery made against the complaint in a matrimonial court. Another case is P versus P. The wife was seen in a semi-naked state in a hotel with a stranger. The court held that so long as the act of cohabitation is not proved beyond reasonable doubt, adultery cannot be concluded, so that the grant of decree of matrimonial relief is not possible. Friends, in the case of N.C. Das versus Mae Das, the husband is often found in the company with a person of ill repute, or with prostitutes, or with lady of immoral character. The court held that all these facts are not sufficient for the proof of adultery. Friends, in the case of H.T. Veera Reddy versus Kistamma, the Madras High Court held that the birth of a child after 402 days of separation from the husband is a clear evidence of adultery. No child can be born of so long separation. Procreation is itself a proof of adultery. Redespa Locator is a famous Latin magazine of law of tort, friends. Friends, child is conceived through the husband cannot be proved by DNA test because individuals do not have a right to ask for DNA test for paternity determination, and the same was held in the Rohit Sekhar versus Narayan Dutt Tiwari case. Friends, the next case is husband versus wife. In the year 1987, wife was charged with adultery when she became pregnant after the vasectomy operation of the husband. The court held that this operation in itself does not prove adultery on the part of wife. Friends, after the discussion of this, we may think about certain points. Is divorce a means of abandoning the supreme dharma of spouses, is staying together, or is it a necessary tool of today's time to break free from unhappy and burdensome relationship? The relationship of marriage theory help preserve marriages while the fault theory undermines them. Which theory is more appropriate when considering the true purpose of marriage? The next is, does the act of adultery undermine the very foundation of institution of marriage? Should court be lenient towards such acts on the ground of privacy and personal liberty? So these are critical points. On that basis you may think about that. Friends, therefore I am concluding my today's lecture. Today I will cover two different parts. One part is history of divorce, theory of divorce, and provisions related with divorce under the Hindu Marriage Act. On the another hand, I also discuss with you about a specific ground of the divorce, that is cruelty, friends. Friends, as I discussed with you that in under the Shastric Hindu law, we have two different kind of approach. One approach is marriage should be continued because marriage is undissolvable union. But Narad and other scholars concluded that naste mrite cleave cha patito pati. In these circumstances, wife is free to accept or adopt another husband. Friends, Kautil is also very clear that in a case of mutual divorce is available when the marriage is unapproved form of marriage. Means we have two different kind of provisions in our Shastric law, friends. Friends, after the enactment of Hindu Marriage Act, we enacted the provisions of the divorce, and some scholars argued that due to the enactment of the provisions related with divorce, Hindu marriage is no more sacrament. But as I discussed with you that divorce is exception, marriage is rule. Marriage is sacred because of the performance of yajna. A man cannot perform yajna, only one. They are bound to live together and perform the religious rites and ceremonies. Therefore, friends, Hindu society is still believing that marriage is a sacramental character and a sacred union, friends. Friends, we also discussed the idea of the divorce under the statutory law, under the customary law, under the statutory law. We also discussed the fault theory, frustration theory, and the mutual consent theory. I also discussed the grounds available to the husband and wife both, section 13 subclass 1, which includes 8 grounds. Ground exclusively available to the wife, section 13 subclass 2, which consists 4 arguments, 4 grounds. And after that, friends, we discussed about the adultery as a ground of divorce, friends. Any kind of the consensual sex after the marriage is adultery, is not a rape. and adultery is a matrimonial offense, and therefore marriage may be dissolved on that basis. Friends, please recall Josephine case properly, because in Josephine case adultery was declared unconstitutional in respect to the criminal law, but in the respect of the personal law it is still recognized as a ground of divorce, because marriage is an institution which is dependent on the faith and confidence. If a married man involved with a sexual relationship with other person, it is not allowed, friends, and therefore adultery exists as a ground, friends. But proof of adultery is a typical task, friends, because adultery happened so secretly, therefore it cannot be proved by proper evidence, friends. But court also think that so long as you are not proving the adultery with proper argument and evidence, mere suspicion cannot provides you grounds for the dissolution of marriage, friends. Therefore, adultery must also be established properly. This is discussed in the class. So therefore, friends, after this I am concluding my today's lecture. Thank you, friends. Thank you.